So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being. I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
Today's case features a self-proclaimed sovereign citizen who's managed to land himself back in court barely a week after his last hearing. Fresh out on bond, he apparently decided it was a good idea to steal liquor from a convenience store. Just days after being released, now he's standing before the very same judge, who looks completely fed up with his antics. The exchange that follows is nothing short of courtroom gold. So here's the question: after violating bond so quickly, should he get another chance, or is it time to keep him behind bars for good? Let's get into how this hearing plays.
All right, people of the state of Michigan versus Drew James Peltola, files 247831 SM. And file 247819 SM. Mr. Peltola appears from the Dickinson County Jail. Counsel
appellation known as Drew James Peltola appears before you as an entity.
Hold on a minute. Just let me make the appearances, and I'm going to give you the floor, okay? In regard to the matter, Nancy Schaub is here as both his counsel on the underlying file on 247819 SM, as well as the first bond violation. She's here as CAFA counsel on bond violation number 2 in this file, as well as a new file of 7831 SM. Kristen Cass is here on behalf of the prosecutor's office. Drew Peltola, I'm going to give you an opportunity now to say whatever you want to say. Go ahead.
I was trying to get a ride to court this morning. This bond violation.
Wait, sir. I don't want you to talk about the underlying charges. I wanted you to say whatever you wanted to say. I thought you started to say some sovereign citizen information that you wanted to make a record of.
I am an American non-citizen national that's defined in the United States Code. And I do believe that underneath copyright, once my name is copyrighted through the Daily News, once I put that copyright on your paperwork, that's something called copyright impoundment. That means that under Erie Railroad versus Tompkins, the fictitious entity under due process of law does not apply to my sui juris living being.
In court, this self-proclaimed sovereign citizen tried the classic "I copyrighted my name" move, thinking it would somehow shield him from prosecution. The idea comes from a common sovereign citizen belief that by copyrighting their name, they can prevent the government from using it in legal documents, as if it's a loophole to opt out of the justice system. Supporters of this theory often claim courts are actually private businesses and that legal cases operate on hidden contracts. But this claim has been debunked countless times. It's no more valid than denying gravity because you don't like the idea. Whether he truly believes it or is just grasping at straws, the result is the same. It's not going to work.
All right, is there anything else you'd like to state for the record concerning this issue then, Mr. Peltola?
No, there's not, Your Honor. I would just like to be released again on a PR bond. You have expedition charges. I'm asking the courts to please release me on a PR bond again, and I'll continue to abide by court rules and stay off of drugs and try to maintain my court dates.
All right. In regard to the matter, then, Mr. Peltola, I have an advice of rights and plea, and for the record, I will acknowledge your comments, your objections in respect to the court's jurisdiction and whatnot are noted for the record. All right, concerning the matter, then, I have some concerns regarding Mr. Peltola. He seems to be on a spiral. This started with a disorderly drunk on February 4th in a public place. I saw him on February 5th. I set his bond terms. I saw him back on February 12th, with a .236 on a preliminary breath test. I set bond at that time on the bond violation and the underlying. And the reason I told him then that I was going to give him the break is that normally I see people in between. They get arraigned, I give them the warning, And then they come back on a bond violation. He had not had the warning in between because he violated his bond so quickly that I saw him all at once. So I told Mr. Peltola at that time that I would set the bond at a 1,000 PR, but understand that if he came back again, he would leave me no opportunity or new choice. So here we are, not even a week later, on February 19th, stealing alcohol from the Norway Quick Stop, involving another bond violation, as well as a new underlying charge that I'm free to assume is true for purposes of setting bond. So for purposes of setting bond today, then, for the following reasons, and in regard to his Wisconsin matters, very serious matters, he's got 2 felonies pending in Brown County from 2023. The first one alleges possession of narcotic drugs, a felony, possession of a controlled substance on or near certain places with a modifier, carrying a concealed knife, possession of drug paraphernalia. That case has been pending through for quite some time. And he has a court date for a status conference scheduled for February 26th at 11 a.m. Then, so the date of this offense was filing date of 2/10 of 2023. He's got a filing date of March 15th of 2023 in Brown County, another felony alleging bail jumping as well as possession of drug paraphernalia. Likewise, that has a court date at the same date and the same time as the other pending felony.
I think that is part of the other pending felony. They charge it as a separate offense, but
It's a separate case, total separate case, total separate charges, total separate bond, total separate court dates. This is file 23 CF 448. The first one is 23 CF 240. So in respect to the matter, my point being, for purposes of setting bond, Mr. Peltola has some substance abuse issues going on. He's got numerous cases pending in Wisconsin as well as now here. In regard to the matter, Mr. Peltola, I'm going to direct you to talk to your lawyer. I'm setting bond concerning the new theft case. Then the conditions are going to be as follows. Mr. Peltola may not enter into the Norway Quick Stop as a condition of his release. He is not to purchase, possess, or consume alcohol or non-prescribed controlled substances. Mr. Peltola is subject to random PBTs and drug screens. Mr. Peltola may not go in any businesses that sell alcohol for use inside, such as bars and taverns. Recreational and medicinal marijuana use and possession are prohibited until or unless further order of the court. Conditioned on him signing that waiver of extradition, which I do have in the file, I will allow him to go back and forth to Wisconsin for purposes of court hearings and or meeting with his attorney.
It's puzzling why the judge hasn't taken a tougher stance on this sovereign citizen. He's already shown zero respect for the law, from stealing liquor to pushing the bizarre, copyrighted name, defense, as if it somehow makes him untouchable. This isn't just about breaking the rules. It's about rejecting the entire concept of accountability. Letting someone like this walk free again feels like inviting more trouble, especially when history shows he'll likely repeat the same behavior, if not escalate it. At this point, denying bond might be the only way to prevent further damage. What do you think? Is it time for the judge to finally draw the line?
If
in residency, he lives in Wisconsin.
in residency. No, he lives in Vulcan. Or he says Vulcan. Is that just your
Bracketed.
mailing address?
Yes, we can do it like that if you choose to.
Well, where is your residency?
My
Well,
residency and my domicile is 1968 River Street. We can switch it with a mailing address to W43, the apartment 13 in Vulcan, Michigan. The address should be in there. It should be bracketed.
Right, and that's apartment 13. You didn't put that on there though. Apartment 13?
Yes, ma'am.
And that's your mailing address though?
Yes, but the problem is that building's not registered anywhere. I had to go to the post office and I had something mailed and they told me that my mail was being returned and because there's no actual mailboxes in the building.
All right, so I got 2 issues I need to deal with here. One, do you live in Wisconsin? Do you have to go to Wisconsin for purposes of residency or just your court stuff?
My mailing address, my residency, and my domicile are all registered at my mother's house. There was some unexplained events that I will not say out loud.
I don't know where your
protected
mother's house is, Mr. Peltola.
Nine
Ma'am.
address.
River Street, Niagara, Wisconsin, 54151. My mailing address will be W45. That's the Norway, the Vulcan address. I can't remember that off the top of my head.
All right. So in regard to bond, then condition on him signing a waiver of extradition, I'll allow him to go back and forth between Michigan and Wisconsin for residency, court appearances, meetings with his attorney. In regard to the matter, if you relocate for any reason, you must provide the court with an updated address and phone number within 7 days of any change. Concerning the amount of the bond on the new retail fraud, I'm going to set that. I'm going to set that at 1,000 cash surety, 10%. In regard to the newest bond violation, then I'm finding for both of them, actually, I'm going to make a record based on the factors the court is required to consider under MCR 6.106, considering the frequency, the charges, the dates that I have mentioned, as well as the ongoing Wisconsin matter. I am finding that to release him on a personal recognizance bond would not adequately ensure public safety. In regard to the bond violation, concerning the matter, then I am going to set the bond violation at 2,500 cash surety, 10%. So, Mr. Peltola, those bonds are set. If you get out, you make sure to get in touch with your lawyer. If you're in
Can I say
custody,
something?
she'll be in touch with you. You may.
Yes. You know, I don't understand how I can tell you that I'm an American national and you can hold me in a county jail under bond, especially today when I was arrested on a larceny under $200. Somebody changed case prefixes and the warrant got dropped to a misdemeanor. And now you're still going to illegally hold me in a county jail under bond?
Also apparently, because he calls himself an American nationalist, this sovereign citizen thinks he knows more than the entire legal system. By his logic, the court should just drop all charges and let him stroll right out the door. In reality, he's accusing the court of holding him unlawfully while treating crime like it's part of his daily routine. The contradiction is glaring. Demanding rights while breaking the law at every opportunity. Whether he truly believes this or is just trying to outsmart the judge is anyone's guess, but either way, it's not a winning strategy.
All right, Mr. Peltola, I'm not going to argue with you. Your sovereign citizen has been noted for the record. In regard to the matter, you are under the order of the court. You're under the jurisdiction of the court. I decline to follow what your...
Can I at least tell you, admit I was arrested on a larceny charge that was dropped through a case prefix, UN, all incoming evidence? Can I at least have you admit that in the court of law that you guys illegally kidnapped me again with a larceny through John Rod D. Clark, Norway Police Department? Can I just have you admit that once?
No, Mr. Peltola, I don't even know what you're talking about. I will not admit that. Thank you to the jail. We are off the record on this matter.
The judge really could have set a much higher bond here. Does anyone honestly believe this guy won't be back out causing chaos the moment he's released? His track record shows zero accountability, and it's hard to understand why someone repeatedly committing crimes, while shouting conspiracy theories, should have such an easy path back onto the streets. It's like handing a match to someone who's already burned down a house. The risk is obvious. This isn't just about the charges he faces now, it's about the message it sends when someone ignores every rule and still walks free. There's always a balance between fairness and public safety, but in a case like this, you have to wonder if that balance is tipping too far.